So it's just wondering if you wanted the break now or later. That's
Sure,
up
let's
to you.
take the break now. Let's take the break now.
Sir, before we take the break, I just have a quick application. I apologize, sir. I think it's important. I've just met Mr. Alexander Cohen. He's present in this room. And, sir, Mr. Cohen, as we have heard throughout this proceeding, has relevant and material evidence to this proceeding's mandate. He has very relevant evidence with respect to the inquiry as to the circumstances, as to the invocation of the Emergencies Act. He also has relevant and material information with respect to misinformation, of which this commission has been tasked with exploring, beginning with the text messages between himself and Mary Liz Power that are already in evidence, in building the narrative with respect to the protesters in Ottawa being extremists, and thereafter essentially setting out that they are, in fact, proprietors of Nazi symbolism. Sir, this commission has been hearing from various...
Can I just interrupt?
Yeah.
What's your application?
I'd like to call him as a witness, sir.
Well, have you written any, is there
I didn't expect that we would have the opportunity.
Well, you haven't at the moment. There's no application. So
Well, this is my application, sir. I'm making it orally, and I'm asking for the commission to have him testify after the minister. He has relevant material information.
I'm not going to do this orally right now.
Well, sir, we're given 15 minutes to cross-examine, to elicit relevant and material evidence. And we have relevant and material witnesses here. The Government of Canada has redacted without lawful authority all of these statements from these staffers and have suppressed records.
I have no idea at this point where this is going, so I'm going to take the break. And if you can speak to Commission Counsel, which I think I've repeated many times, is the way to at least raise the issue.
Yes.
And then we'll see if they can resolve it or not. But we have a schedule. And
sir, the schedule is not as important at getting to the truth.
There's no question we want to get at the truth, but you know what? It's a very complex issue, and it's not all about what you want. It's about what the commission needs to do, what the parties want to do,
and I think it's what Canadians are entitled to, sir.
I'm trying to control a process, and we have witnesses, we have a schedule. It's been going for a while. Please speak to Commission Counsel. We'll see where we go, and we'll take the morning break.
Sir, I understand, but I just asked for a ruling after the morning break. Thank you.
So we'll take 15 minutes.
The commission is in recess for 15 minutes. La commission est levée pour 15 minutes. The commission is reconvened. La commission reprend.
Sir, okay. The Commission Counsel has not completed her
I understand, but sir, and your counsel's advised you that.
No,
I know you've directed.
I'm sorry,
you wanted the application.
I'm speaking.
Yes, sir.
The application, if you want to do it, you've been advised it's to be done in writing, not in the middle of the presentation.
Sir, we filed 2 motions in writing at your direction that you've refused to rule on with respect to the redaction of documents from the Government of Canada.
You're speaking.
That has not been ruled on, and they've been filed for days.
I will take a break while you're asked to leave. I will return in 5 minutes if security could deal with the council.
The commission is in recess. La commission est levée.
Now, cross-examination. Start with the convoy organizers, please.
Good morning. Good morning, sir. My name is Keith Wilson, counsel for the convoy organizers. I apologize for my voice. I'm recovering from a cold.
I have a bit of the same.
Thank you, sir. Sir, we're not in a position to proceed with cross at this time, and there's two reasons. One is the federal government has disclosed over a week ago an extension volume of documents that are highly redacted. It is obvious from the face of the documents that they don't meet the criteria for lawful redactions. A motion was made last week for those redactions to be lifted. The submissions closed on Thursday evening. We still have no ruling. A number of days have passed. For the cross-examination and the discovery of truth process to be valid and effective, the parties require access to the documents. We don't have that. So we would appreciate some indication as to when the Commission is actually going to rule on that and hopefully compel the proper disclosure of the records so that cross-examinations can be effective. I emphasize that these documents are not related to future witnesses, but present witnesses. So we're making the process inefficient with all due respect by not allowing the parties to have access to unredacted documents. Second reason we're not in a position to proceed with our cross-examination at this time with this witness is our lead counsel, Mr. Brendan Miller, who had prepared for the cross, as you know, sir, has been removed from the room by you when he was raising a motion to find a way around the absence of a ruling on the redactions. So we're just not in a position to proceed on cross, sir.
Okay, well, just on your first question, it is expected that the ruling will come out at during the lunch hour. There have been a fair amount of back and forth without going into detail. There's some, let's say, innovative type of issues that had to be dealt with. So that should come out at the lunchtime, which I'm happy to, I will do my utmost. It's going to come out, unfortunately, probably not on the record, the website, because it won't be translated, which is one of the issues we have to deal with. But we will, in light of what you say, we'll issue it in English only for the moment, and it will be posted when it's bilingual. But I understand that submission. So that should enable you, so we can put off the cross-examinations till after the lunchtime. In terms of the other problem, that's not something I can deal with. I'm trying to deal the best I can with the situation, and quite frankly, if the issue had been raised the way you have now, I would have given the answer I'm giving now. So what I propose then, since this witness will be here after lunch, we simply delay till after lunch. If you could endeavor, because I see you have, you have a co-counsel, so can sort out how that can be done, that would be appreciated.
Thank you, sir.
Okay, so next I'll call on the OPP, please. That's to be encouraged. I may even allow that. So I think we'll take the lunch break now and come back.
Commissioner, if I may, just a couple of comments before lunch. Rob Kittredge for the Justice Center for Constitutional Freedoms. I just wanted to express regarding the removal of my friend Mr. Miller this morning. I wanted to express the Justice Center's position on asking that you make a decision about his return to the room during the lunch break, and express our support for his return to the room at the earliest convenience. I'm a big supporter of constructive communication, and I understand that may not have taken place this morning, but I think his clients have a right to representation here, and we'd like to support his ability to cross-examine Mr. Mendocino today. If you can make that decision at lunch, that would be very much appreciated on our part.
I'm certainly a favor of communication. I believe that the convoy is still represented, so it's not a question of no representation. I'm not aware of a request that he return to the room, but if he requests it, I will consider it.
All right. Well, thank you very much.
The commission is in recess until 2 o'clock. La commission est levée jusqu'à 14 heures.
Convoy organizers, please.
Thank you, sir. And just before I start, I apologize for talking over you earlier today.
Okay. Nation?
No, Commissioner, no re-examination.
Mr.
Okay.
Commissioner, it's Bath-Shéba Vandenberg,
Yes.
co-counsel for Freedom Corp and protesters.
Yes.
There's been an unredacted document shared to the parties by Counsel for Government of Canada at 4 p.m. Pursuant to your decision earlier today. It's the document ssm.can.407721. We advise that the Commission Counsel should look at it as it is relevant and material to this witness. In particular, Jody Thomas, the National Security and Intelligence Advisor, states in that document that there is no national security threat pursuant to Section 2 of the CSIS Act.
I believe that point was canvassed this morning with the witness, that it was put to him that it had been concluded by CSIS that there was no threat pursuant to Section 2 of the CSIS Act.
Mr. Commissioner.
Yeah, I guess maybe just have the document
Sure.
put up.
If we can have the doc ID number.
The ID number is ssm.can.407721.
Mr. Commissioner, it's possible because of the timing of the disclosure, it's not available in the party database right now. But the clerk's been emailed a copy.
Yep, so I do have a copy and I'll put it up on the screen shortly.
Okay, let's read this then. Can we scroll down a little bit, please? A little bit more, please. Okay. NES spoke with NSIA, it looks like, and Jody Thomas, but the NSIA is Jody Thomas. Section 2 of the CSIS Act, violence not met. Wonder if we need full 30 days if Ottawa cleared. I suppose the question would be, Minister, were you aware that it had been concluded that Section 2 of the CSIS Act was not met?
Sorry, what is the date of this note?
I'm afraid I don't know.
Well, look, leaving that aside, yes, I was.
It says it's before the speech Monday morning, which
Okay.
is the date that they announced the invocation. That might assist.
Okay. Yes, I was aware that CSIS had concluded that Section 2 under the CSIS Act was not met. I was aware of that fact.
Thank you.